live episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation, and welcome to another episode of Surviving the Survivor. It is the podcast that promises to bring you the very best guests in all of true crime. It is not just a tagline. It is our reality. We've got a new best guest tonight, and we're going to just dive into this with both legs. I was going to say head first, but we'll go both legs this time. We are awaiting a third best guest who would be none other than Susan Constantine. She is the owner and founder of the Human Behavior Lab. She's a jury consultant and the author of How to Spot a Liar in 7 Seconds or Less. You guys know Ryan on the bottom. He is a former homicide prosecutor in this very county. The same job that Will J. and Dave Cacciatore have currently is his old job. Now he is a victim's attorney. And new to the show, I met her. This is what happens when you go on location. You meet interesting people. And I met Candy, and I said, hey, Candy, do you want to come on STS? And she obliged. This is Candy Eaton. She is a former public defender investigator, over 30 years of experience doing that. And now she has a private investigation firm. So she's going to give us a totally different look at this, a totally different angle. And to be honest, I don't know what it is, but I'm curious to find out. Let me just start with a couple things real quick. So I did speak to Kevin Beck, and I'll be totally honest. I cannot remember if it was yesterday late in the day or early today. However, I asked him, how do you think Sarah Boone did on the stand? And his quote was, she did very well. Now, this afternoon, I know for a fact, I spoke to Tony Henderson, chair number 2 for Sarah Boone, and asked him the same question. He paused for a really long time, like a 30-second pause, which is an eternity when you're in a men's bathroom. And he said, we'll know for sure once this is all over. That was an interesting answer, and I guess appropriate because he obviously did not have an answer. But he obviously, thinks it went okay, and time will tell. Candy, since you're a private investigator, I have a couple of interesting, what I think are questions that I would like to ask. As far as I know, Jorge Torres had no history of violence before meeting Sarah. I don't know that the state pointed that out. Ryan will correct me if I'm wrong. How important a fact is this if it is true? And from an investigative, like for your job, if you were working on behalf of the state here, what would you do about this?
So from the state's perspective, you don't want to really tiptoe on that line because he is the victim and he is deceased. It would be more of the defense type of job to dig into Mr. Torres's past and show more of a history. For example, I don't know if Mr. Torres has a detailed history. I know he has a history here in Orange County with Sarah Boone, but he did come from Pennsylvania, I believe. So I don't know what his history is there, but that would be a defense, job to dig into Mr. Torres's history. Did he have a history of violence before Sarah Boone? Kind of laying that groundwork, showing that this is not new behavior, or this is his type of behavior.
Yeah, and if she was 5150 twice, for those of you who do not know, it's another term for Baker Act. That's what they call it here in Florida, and that is basically when you are taken for 72 hours to a hospital if you're exhibiting odd or strange behavior for your own protection. So there you go. Joel on scene in the elevator and bathroom. Ryan's the only other person who could defend me on this, but men do talk in restrooms. You get a lot of information in there. So I've gotten some of my best info in there. A couple of housekeeping points here, and then I'm going to get to Ryan on some stuff. The defense plans to rest in the morning, in the AM. They actually said they wanted to rest this afternoon. There was a little issue with some no contact orders that I will ask Ryan about momentarily. And so, they were going back and forth. It was decided, okay, we'll just rest in the morning after getting a couple things out there. And then the state will have its rebuttal. I asked Dave Cacciatore in the hallway, not the restroom, in the hallway, how long do you think the rebuttal will be? By the way, he seems like a genuinely nice guy. And I'm kind of coming around on Will J. I think Will is probably just a little quirky, but nice. By the way, I look jaundiced. That's just my horrible lighting here. You guys do not have to put me under a little like barbecue light like they do with babies. I'll be okay. I'm not jaundiced. However, on to this. The defense plans to rest. The state will have its rebuttal, as I said. Now, Ryan, they've announced in court today that they plan to show, I think, almost 2 hours worth of body cam footage and also reading of text messages. Now, we saw the deputies responding to this scene. What do you imagine all this body cam footage is going to be that we will watch tomorrow in court?
First of all, I'm continually impressed with your ability to scoop a story no matter the location. But putting that aside, the state's likely to show what Sarah Boone's affect was during this time period. So much has been made about battered spouse syndrome, PTSD. We heard so much about today, and Owens and the defense are really trying to paint this picture of somebody who was so scared and so frantic that she committed the acts that she did. But I suspect, I haven't seen the camera footage, but I suspect it's going to be of Sarah telling different versions of stories, not saying that she's scared, acting with lack of affect, that the state's ultimately going to argue that the defense that she's bringing forward is not credible. And you saw some of that today through the cross-examination of the psychologist.
Two interesting comments right off the bat. Lynn M. as a survivor, the leaving him in the suitcase and going upstairs does not fit with being afraid of him. She would have wanted to get away. And listen, juror number 5, I'm going to go through it. I believe it's juror number 5 is the DV victim. And she's been taking a lot of notes. Since I brought it up, Candy, what's the experience been like for you inside that courtroom, and what are you making of the jurors?
The juries, the poll seems to be really paying attention. There's some of them that are just not taking notes, kind of looking around, but that's just a few of them. But I'd say most of them are really interested. Yesterday, when the prosecution opened up the suitcase, had Sarah Boone step out into the well, the jury stood up. They were all very interested, even though they were right there and they could see, they stood up. They were very interested in seeing what's going on. I see a lot of ping-ponging of heads, watching, what the judge says, whoever's on the witness stand, back looking at the prosecution. So they seem to be very interested. I don't see a lot of facial gestures of, like cringing or being emotional. Yeah. Yesterday there was shown pictures of Sarah Boone's her wounds, and I didn't see any cringing or anyone getting sick by looking at those photos.
Yeah, and no, and they've got really, I think, very good poker faces for the most part. From Poetic Justice, a great question. Ryan, to you, have they has the state failed to sort of humanize Jorge Torres? Are we going to get that on the back end here with the rebuttal? I've seen a lot of people say that. Someone said the state's getting killed, and then you see I'm So Tired, who says state is going well, jurors are not stupid. Do they need to humanize him more?
Yeah, you're going to see some of that, I suspect, through the rebuttal. And this is where these types of cases are really hard to present, because every person who is killed is a person who has a family, who has a life, who has connections. And the rules of evidence and the case law on what's admissible in court is not victim friendly. It doesn't allow a presentation of who the deceased is while the guilt portion of the trial is going on. And the court's rationale behind that is that jurors should be making decisions of whether a crime was committed and is the defendant the person who committed the crime, without feelings of sympathy or bias. The jury's going to be told in the weighing the evidence instruction, you should not base this verdict on bias or your feelings towards, either of the parties in any way. And it seems counterintuitive, I think, especially for people who watch trials. And it seems very unfair that so much is made about Sarah and her background. It's a tough situation, because we do want defendants to exercise and have all of their rights under the Constitution. And we really do want juries to reach decisions not based on sympathy or bias, because in this situation, it cuts both ways, as we've talked about throughout this trial. Are there going to be jurors that are sympathetic to Sarah being a domestic violence victim and give her a pass because George got what he deserved, or things like that? So I do think the state's going to try to bring in both Sarah's potential in history of violence towards George. The state may be able to bring in some evidence that George had a good reputation, but they're going to have to be very careful about that to not create appellate error.
For those who did not see the live stream of court proceedings today, really, I think the most important witness to discuss outside of Pearl Williams, who's a personal favorite of mine. She was Sarah Boone's neighbor, and she was wheeled in, and I love the name Pearl, and she was just exactly what I was expecting and hoping for. She was awesome. And she ran that room when she was in there. So I wish to see how we could cut a little video of her, but I don't think she's going to be able to do that. Because once again, no school for my kids because there's a Jewish holiday today again. So I'm just wondering, here's a comment. Do you think her narcissistic personality, nothing her fault, and she wants to teach him a lesson? The bigger question for me to you, Candy, you're not a psychologist, so feel free to comment on that. But what has been your impression of Sarah in the courtroom?
I think she's been well behaved. The jury has not seen all of the antics that we have seen over the years, with changing of attorneys, making demands, coming to hearings and spouting off, writing letters about attorneys and writing bad letters about judges. The attorney doesn't, the the jury knows nothing of that. So the rest of us can see all of those narcissistic traits that have been kind of happening over the years. I don't really think that the jury is going to be able to hone in on any of those traits. She's been well behaved. I don't think that they're going to tap into that portion.
Well,
although you go ahead, Ron. Go ahead.
Yeah, it creates an interesting dynamic. And we heard this in the trial at the start of the defense case. Normally, a defendant is going to be called last, just strategically. We know that the opposite was true here to get the self-defense in. So I think to Candace's point, and it's an interesting thing for me, you're now having a jury who saw her speak And now today was so much about her and the analysis of her, which I don't think helps her case, because they saw Sarah, if they believe that Sarah had a weird affect or didn't react exactly the way that they would have, now they've heard about alcohol dependency and narcissism. So those may be things that color the jury's perspective of her in a way different than would normally exist.
Interesting. Lita Randolph here, and I want to get back to Ryan on this, but we don't know if the DV victim will be one of the 6 jurors. Ryan, if I understood you correctly, jurors in order in the front row from left to right will be the first 6. Is that correct?
That's correct, unless one of them is discharged prior to jury deliberations.
Okay, so that means that the DV juror is one of the 6 for sure. And, she's been taking a lot of notes, and she's really good at not, giving any sorts of tells. She is very stoic up there. Juror number 2 is a woman, I'd say, in her 50s, maybe. She's got kind of, to me, and Candy, correct me if I'm wrong, she's sort of the most lively facially speaking. Like she'll look over at Sarah, she'll nod her head. It's just tough to tell what she's thinking. And what's interesting, Candy, I think, is she's sitting next to juror number 1, obviously. And he's, I say this lovingly, he's like grumpy juror. He just has kind of a grumpy face with a comb over. And he and juror number 2 are getting along swimmingly. They obviously are not supposed to be talking about the case, but it seems like they would be in agreement in a deliberation room. But what have you made of, juror number 2 and the DV juror?
The DV juror I see I'd say she's probably the most engaged out of all of the jurors. And, as Ryan was saying, she could be that alternate to be cut. But she seems to be very, very involved, taking this very seriously.
They're great questions. I'm going to throw this one to you also, Candy. So I'm going to ask Ryan a couple of legal things in a moment. From Ambala Lady, why hasn't the prosecution, in your opinion, Candy, made more of the suitcase being thrown down the stairs? We now know the defense was that she was dragged down by her hair. Should the state be countering that? Will they do that, do you think, in the rebuttal?
I hope so. I feel like that has not really come to the forefront, that, this started upstairs, and the her taking the bat to the suitcase has kind of been taken light as well. So, I mean, Mr. Torres took a beating while in that suitcase, and, maybe the state will pick it up going forward. But up till now, it hasn't really played a big part, I don't think.
Yeah. From Wise Child, was it Joel's phone? No, it's the same guy. I want to call him elderly because he's not elderly, but he's fully white haired. He's got a YouTube channel of some sort. I have no idea what it's called. Kind of an odd character. And every day, either his laptop goes off or his cell phone. It happened again today, and the judge reprimanded him again. I'm shocked that he has not thrown him out there yet. So just getting back to tomorrow. So then the state will rebut. They say that's expected to go 2 hours. After that, they're going to be jury instructions and then closing arguments. But Ryan, Will J with the state said, look, jury instructions should fly by. They're simple, except for rule 3.6F, 36F. What is that?
So 3.6F is going to deal with the credibility of witnesses. And it's also going to deal with the self-defense instruction. So the Florida self-defense instruction is completely confusing. It has a lot of parts to it that Sometimes you give if the testimony allows for it. Sometimes you don't. It's very convoluted. So obviously, since both sides have been fighting about this self-defense piece the entire time, what you're going to see is you're going to see both sides posturing to either include or exclude pieces, but you're also going to see a lot of conversation about objections to the self-defense rule. One of the biggest ways that trials get overturned in the appeals court are because of bad jury instructions. So the court has to take very deliberate, focused, painstaking effort to ensure that the law is correctly identified, that in some of these instances when parts of instruction should or should not be given, that the court makes the right decision. I would also not be surprised if, especially on the defense side, they're going to want to add special portions or additional portions to the standard instructions. And just so everybody knows, all courts, including here in Florida, there are standard jury instructions that are published by the Supreme Court of Florida based upon the input of judges and lawyers. The court is given those as a guide. It's not mandated under the law that all of the standard instructions be given. Parties are able to recommend what we call special jury instructions if they believe an extra area of the law needs to be defined. That can be a great benefit to an attorney, to a party that's able to do specific instructions. One of the things that gets very difficult is oftentimes if the parties or the court do not anticipate what the jurors' legal questions are going to be, you get into a situation where you're hours into deliberation and the jury asks about heat of passion, for instance. I had this happen in a second-degree murder self-defense trial where nobody decided to further define the term heat of passion. And 13 hours into a deliberation, the jury wanted a more definitive instruction. Unfortunately, once the jury starts deliberating, the court has very limited ability to give additional legal instruction. So at that point in time, you have to tell the jury, well, debate it and use your common sense on what you think this means, which is, good luck getting 6 people to agree on what to have for dinner, nonetheless, what something like heat of passion means. So,
but it is easier than 12. It is easier than 12, right, Ryan?
It is, and that's definitely going to be to, I think, the state's benefit here. But these juries, nothing has flown by in this case at all. So I anticipate the jury instruction charging is going to take, more than an hour to go through at least.
That was my next question. It's interesting that you say nothing's flying by because my first time in Orange County, and I feel like it's going at a really fast pace, but it's interesting to hear that. True Lifestyles here, friend of the show, Sarah saying she left the zipper open a tiny bit is a ridiculous defense. Candy, some people were just commenting that she showed absolutely no real emotion when this was happening. And, quote unquote, real DV survivor would be triggered, would be nervous to go up there, be hesitant, reluctant. She was like jumping up there because she knew she was center stage on Broadway. What do you make of that?
So when prosecution asked her to step down into the well, my first thought was, she's not going to do it. She is going to put up a fight. She's going to resist. She's, going to become traumatized because she hasn't seen this suitcase since that night. And so, at first thought, I thought that was going to happen, but she seemed very helpful to get out of the witness box, come down. She was ready to jump right in there. And Mr. Owens jumped in to assist her. She asked, do you want me to demonstrate the bat as well? That one kind of threw me. I didn't see that one coming. So maybe it's been a long time, it's been 4 years. So maybe she's, kind of maybe suppressed those feelings. But yeah, she had no problem touching the suitcase, looking at it. There was no problem.
Yeah, a lot of people pointed that out. Thank you to a friend of the show, Analytical Blarney AB. From Janet Lindsay, did you feel that Dr. Harper was more reluctant to answer William J's questions? Her voice even got lower. I noticed, she definitely sounded a little nervous. And I thought that was a fantastic cross, which I'm going to ask both of the guests about in a moment. But first, there was sort of it seems like this happens every day. There was a very last minute motion from the defense to admit into evidence 2 no contact orders. And then that was objected to. And then what was kind of at issue was the defense wanted to get a court reporter to, I guess, verify it. And Will J did not, he said he just didn't want a poor courthouse employee, not literally poor, but a poor old courthouse reporter, to have to come up and basically spend their time doing this. So then he kind of withdrew his objection. And so these contact orders, it looks like they'll be admitted in. Ryan, what is the importance of this? And I guess, does Sarah have to come back on the stand for the defense to, I guess, validate the no contact orders?
So it's just another example of trashing George and just trying to show that he was so bad and so aggressive towards Sarah that the court entered no contact orders. What was interesting about this was, first of all, at least one of the contact orders was from a misdemeanor case. And why that's significant here in Florida is that was a no contact order associated with an arrest, as opposed to an injunction for protection against domestic violence or stalking or repeat violence. And that's a very standard item in Florida, that whenever there's a victim case, the defendant is ordered by statute to have no contact with the alleged victim. So the existence of that order associated with an arrest really has no significance in that a court found that there was additional items of violence. It's a protective measure. Sarah is not going to have to authenticate those because the court is allowed under Florida law, and it's true in every jurisdiction. The court can take what we call judicial notice of its own records. And what that is the judge saying, on behalf of the court, I am taking notice of the existence of this document. So it just becomes a way to where you can streamline the admission of the piece, and we'll see how the state responds to it.
From Sandy here, hello from sunny Mexico. What is the maximum sentence, Ryan, that she can receive if found guilty, keeping in mind that she rejected a plea deal that would have probably had her out in about 8 years? But what's the answer, Ryan?
So the maximum on the second-degree murder is life in prison. And it's important to note that in Florida, unlike most states, life is life. The only way that she leaves the Department of Corrections, if she's sentenced to life, is either by clemency granted by the Florida cabinet, or she leaves in a coffin after she's deceased. There is no parole in Florida. It hadn't been parole since 1988. Now, the sentencing guidelines in this case for a second-degree murder will call for about 22 and a half years on the low portion of the guidelines, up to life. Now, the court can deviate downwards for a few reasons. I don't think any of those are going to be applicable in this particular case. So she's going to have to serve 85% of any sentence that she's given. So the rule of thumb is on a 30-year sentence, she's got to serve about 26 and a half, and she'll get the credit for good behavior. So on the 30-year sentence, given that she's been in prison, she'd have to serve about 22 years before being eligible for release. If she's found guilty of manslaughter has a 15-year maximum sentence in the Department of Corrections.
There you go. So if it's 22 years, she'll be roughly in her late 60s, early 70s, pretty much. From Sharkey here, I'm going to go with that pronunciation. Is it possible the suitcase got involved? This is interesting in this whole event because George was trying to pack up and leave. I heard there were things in the suitcase in addition to George. I hadn't really given this thought, but now that she or he brings it up, I guess I have no idea. But Candy, to you, a lot of people are suspecting with that baseball bat that she is not telling the truth, and maybe she whacked him with it at another point in time. I don't think we'll ever know the answer to that. The question is, do you think law enforcement did a thorough enough investigation? I didn't realize there was other things in the suitcase. Would that fall, would that be their responsibility? Is the onus on them to have investigated that thoroughly?
Yeah, that would be. But what was interesting about the medical examiner, they did show 3 good sized round dots, starting from underneath his armpit and kind of going down the back flank. And as she was showing those, she was explaining that those were attributed to blunt force. So my thought was that the bat that had caused those circles? Because she, the way they were indicating that the way she used the bat was the handle, the round end, the smaller end of the bat, which would not be a poke that was talked about in court, that she just kind of poked at the suitcase. If those dots, those very large ecchymosis type injuries on his back were attributed to the bat, that was not a poke. And she would have had to hit the suitcase really hard in order to go through the suitcase and hit him. So, and there was mention about her hands kind of being injured while hitting the suitcase. So that doesn't exactly sound like a poke.
And
Ryan,
I would think,
go ahead, Ryan.
Yeah, I would also think that if the scenario was that Sarah attacks George with the bat or some other type of weapon to render him either unconscious or semi-conscious, then you would see in the medical examiner's report much more extensive findings of blunt force trauma, of other sort of lacerations, bleeds, those sorts of items. So really absent that, I think that's fairly precludes that there was some sort of attack and then Sarah got George into the suitcase.
Yeah. For Marplom, I asked Ryan this. I now know the answer. Can she be charged with a lesser degree? Yes, she could be charged with manslaughter. The jury can decide on that as well. We're going to get to Annie K's question in a second, but Ryan, to you, this is a complete hypothetical. It came up in chat, and I think it's really interesting. And it's been brought up a lot with the Menendez brothers case. But if George zipped Sarah into the suitcase and she was no longer with us, where would we be today?
Oh, that's a great question. I have enough belief in the system that we would be in a similar place. However, I think it is fairly likely. I mean, let me be a lawyer and equivocate here for a minute.
Yes, please.
I think there is less chance that we would be on this podcast discussing the case. I think that instances of George having been the long-term victim of domestic abuse and using that as a battered spouse syndrome, I think that dynamic would be a lot less likely, if not nearly possible to present. And I think if you could present that just from gender notions and stereotypes, I think that type of defense would fail with a jury even more. It's the unspoken thing in this case, Joel, that we see female homicide defendants differently. Juries see female defendants differently. That we don't want to imagine these things happen in our communities at all, but especially by a woman. Now, we know statistically that women make up a very small percentage of homicide arrestees or defendants, but it goes against the grain here. And it also introduces in, I think, traditional, I don't want to say stereotypical defenses, but I think a lot of people assume if a woman could commit a homicide, there has to be some underlying reason or motive other than if a male commits a homicide. We know from working with victims, I know from being a homicide prosecutor, that those stereotypical norms don't exist in the real world. But this is where our 6 jurors and the alternates don't have contact with the legal system. So, and Joel, it really is, I think it's disappointing as a commentary to the criminal justice system that we do judge defendants and victims differently. What makes it hard on both sides, from the state and the defense, is that trials aren't about every single fact that really happened, and trials don't tell the entire story. And if you know this from being in news, your broadcast goes to the specific audience that's turned on your channel. It's the same thing in criminal trials, where Will J. and Dave Cacciatore are trying this case to what they believe are the notions and norms of the jury. The defense is doing the same thing. And then that gets sensationalized a little bit because of the coverage that's involved in the case.
By the way, unlike other days, Will J. today seemed much more jovial, particularly after the cross of this psychologist, this forensic psychologist, Dr. Julie Harper. He had kind of a look of, I just, destroyed her, for lack of a better way to put it. I want to come back to Candy about what we were just talking about. If it was the reverse situation, I'm curious to get the female perspective. But Julie Frew, who, by the way, knows this case inside out, she's an amazing mod, and she's invaluable. As the state only has one charge, we just talked about this, Ryan, second-degree murder, is the manslaughter. Is that going to be on the juror instructions? How does that work?
So for any charged crime, the court establishes what are called lesser included crimes. So you think about it as, in a homicide, it starts with a battery, an unlawful touching without consent. It then obviously goes to a felony battery, which is touching that causes serious bodily injury. It goes to aggravated assault, which is intentionally inflicting imminent harm or substantially harm. Then it goes to manslaughter. Then it goes to murder 2. And then if murder 1 is charged, it's murder 1. So the jury's going to get a menu of choices. It's going to start with second degree. The jury's going to be told to analyze the elements of second degree murder first. If they are not unanimous that second degree murder was committed, then the jury is going to step down to manslaughter. Now, under the law, the defense can also ask for aggravated battery. They probably will, just because it puts another line on the verdict form that's lesser than homicide. The difference between aggravated battery and second degree murder is the death, which is never in question. But I've had juries select lesser includeds for reasons that make no sense. I prosecuted a woman for killing her 5-month-old child through starvation. The jury came back and found them, that woman, guilty of aggravated neglect as opposed to homicide. The only difference being the death of the child. So as the defense, you want to get everything out there, but the jury is going to have a number of choices that they can make.
Yeah. Everyone's got, I think, a take on this. Steve Jackson, thank you so much for this super chat. These super chats and super stickers go a long way. So thank you. I don't think this jury is going to be willing to put her away on second-degree murder for 22 and a half plus years based on all the DV evidence they've seen and the prosecution's failure to counter it effectively. I'm still going to come back to you, Candy, on the reversing the genders here. But what about this question? Do you agree that, there is this kind of unspoken empathy and sympathy toward female homicide defendants? Are they going to take it a little easy on her, do you think, Candy?
Well, there's a couple things.
Well, Ryan, I'm sorry. I was going to have Candy just address that, and I'll come back to you.
Yeah.
Yeah, that I think maybe historically that could be the case. But yeah, you just never know with juries.
Yeah. And Candy, to you, what about this hypothetical I asked Ryan? Where would we be if George had zipped Sarah into the suitcase and she was now dead? I mean, my personal opinion, he'd be convicted. He'd be convicted on this most serious charge, maybe even a murder one charge. I don't know. But what do you think?
Yeah, I agree. With his more intense, with the DVs against Sarah. Yeah, I could see that happening. I think this whole circus is because she videotaped herself. Had she not done that, I don't know that this would be as big a cessation that it is now.
Yeah, I don't even know if it would be she'd be on trial if it wasn't for that move. But people are self-destructive, and remind yourself, if you're going to hurt somebody, don't videotape it. I think she's guilty. However, thank you for this, Michelle Friesen. However, if I were on the jury and not heard anything, I might be leaning not guilty. I can relate though, because my ex was like, Torres, sorry to hear that. And I saw someone in the chat saying that they're still triggered 59 years. It stays with you for a lifetime. Look, my mom is a Holocaust survivor, and one of the strongest women I know, super sweet, totally down to earth. Is she normal? I wouldn't say that. She's a little, a little different. She's got a little more paranoia. She does, she's kind of lives wondering if the Nazis are coming again. She's got kind of that underlying baseline. So these things never leave a person. A different kind of trauma, of course. Suzanne, member for 5 months. Thank you so much. There was an interesting question up there, COE, that I wanted to get to, but I'm never going to be able to remember what it was. So Ryan, you sent me a text message during Dr. Julie Harper's testimony, and I'm just going to read it if you're okay with it. You said,
Yep.
I'm 20 minutes behind the testimony, but an observation I have with this forensic psychologist about the 3 stages of battered spouse or battered woman or battered person, whatever you want to call it, is that it is an interesting coincidence. Sarah parroted the testimony. She would have known about these phases from the expert. Just explain that a little more.
Well, whoever said that's a genius, first of all, Joel. But
very astute observation.
I'm telling you, sometimes we get it right. There was so much, and we talked about this on the stream yesterday about Sarah acting as if she had to hold George's hand and take him to the bathroom and feed him chicken nuggets and entertain him and all of these items. And you heard that through the psychologist's testimony today about that first phase of the syndrome, where the victim is doing things to try to mitigate the temperature, to placate, to engage. Now, it's my understanding that the psychologist has been involved in this case almost since the beginning. Will, on cross-examination, talked about the 9 times that she had visited, and which she did and did not do, excuse me. But Sarah's going to know, or Sarah knew exactly what this witness was going to say today, and will have had opportunities to review reports and talk with her defense counsel on what the opinions are going to be. They would have had those discussions in deciding whether to call the expert or not. So it did seem very consistent, but consistent to the point where James Owen structured the examination to walk through these 3 phases. Sarah was right on cue saying the same things that the expert was going to say. I'm not sure that the jury would be nuanced enough to pick up on all of that, but there does become a time where if there's too much coincidence, it's not because things are in alignment, it's because things people put those things into a certain assignment.
From Luz, a little off topic, but I'm glad she brought it up. When are you doing a catch up with Donna's case? Donna Adelson hired a new attorney today, and I'm just so I've got sensory overload, so I cannot for the life of me remember the name, but I did tweet it out, and I also put it on Instagram. Twitter's at podcast STS, Instagram's at Surviving the Survivor, and barring court not going late, which it could tomorrow, if somehow they get to jury instructions and closings. I don't think it's going to happen, but if court does go late, we'll probably push the show to next week. Otherwise, we're going to do something on Donna tomorrow at 7:00. So tune in. We've also got Louis Baptiste and Stephen Webster coming on that. And I think Professor Petuto and Webster and Baptiste are must-see YouTube. That is the new phrase, must-see YouTube. Look at this. A big hello from Qatar is the way they pronounce it now. Some say Qatar, but lest you think we are not a global show, you are wrong. We got people all over the world. So hello back to you. And you look very happy and cheerful there in Qatar. Candy, my mom called me last night. I did Ashley Banfield's show on News Nation, which I'm doing today at 10:30. If you guys care to watch, I don't know how I'm going to stay up that late, but that's a different story. But my mom called me. My mom, and Candy, I know you're new to the show. She's survivor. She's also a licensed therapist. And she said, no one really, and I talked about this on the Lunch Live, so it's going to be a little redundant if you watch that. But she basically said, look, this is a really pathological relationship from both people. But she was surprised that no one pointed out that Sarah sought out literally a small man physically, 5'1", 103 pounds. She's got this desire to have a lover on the one hand, but also a child to control on the other, which is so interesting because she has her own child that she's really neglectful of, which is, again, a whole other story. What do you make of, and by the way, she just said that Sarah was punishing George like a little child and took it probably too far. What do you make of that assessment by my beloved mother at 85?
I think she's on point there. The prosecution gave hypothetical questions today to the Dr. Harper that was on the stand, and saying things like, taking away a driver's license, taking away a birth certificate, kind of alluding to the fact that maybe she was holding these things hostage in their relationship. So yeah, it's a very, we're seeing some interesting dynamics with their relationship. It's a boyfriend, girlfriend, but also kind of like a mother, as well, making sure that he's happy, making sure he's fed, getting him to work, very, very mothering. It's very interesting.
Yeah. One thing I can say for sure is if anything, it is dysfunctional at the very least. That is for damn sure. Someone saying life is life. Welcome to Florida, where life is in fact life. They don't mess around in this state. I feel like the victim has been lost in this trial. This is something that Ryan was talking about at the beginning. This is an interesting question with probably a very lengthy answer, so I'm going to toss it to Ryan. Please speak to the Annie K, by the way, is a friend of the show whose dad did a lot of work, psychologically related to victims and so forth. But please speak to the contradiction of the defense's case, Ryan, versus the law enforcement, and her own video evidence? What's going to happen when these two worlds collide in the deliberations room?
Well, it's a great point, and it's a classic example in these types of cases of the state wanting to focus on the facts of the incident and the defense wanting to focus on everything else. So, and this is where it's hard, I think, for those of us who watch trials. Really, we're about 3/4 of the way into the story, and people don't get up and judge how great a movie is or a book is with a quarter left. So this is where the state is going to focus on the video, the 11 minutes, the agonizing conditions that George faced in the last moments, an hour or so of his death, the suitcase. I do expect the state is going to point out that Sarah's version of that night makes no common sense. It doesn't align with the physical evidence and is not demonstrative of people going through this type of mental health response. So the state, if I'm the state, my closing argument focuses on George, is succinct in its facts, and goes ahead and puts the challenge out there to have Sarah explain the time away. And sometimes, in Florida, the state gets a rebuttal closing argument. So the state's going to go first. The defense is going to go give their only argument. And then the state's going to go for rebuttal. So sometimes strategically, you save some things in your pocket for rebuttal because they are items that you don't want to give the defense an opportunity to explain. The defense here is going to go down, and they've been pretty good about getting in some of these concepts like PTSD, alcohol abuse, and they're going to try to argue that. Now, we've seen that Will J. loves to object. He's probably going to object 20 times in their closing, even though there's some goods and bads to that. So really what the defense is going to try to do is the defense is going to mention all these things of how screwed up Sarah is and ask the jury to find her not guilty. Now, under the law, they could have tried to bring forth an insanity defense, which says that I did not know right from wrong and I couldn't appreciate the criminal nature of my act at the time that the act occurred. Insanity defenses have to be specifically pled based upon evidence. Sarah Boone does not meet that description, and I think it was even testified to in the last couple of days. So the defense is going to just bootstrap she's really screwed up, and because of that, she's not a murderer, where the state's going to have to acknowledge that she's a victim, but is also going to have to argue to the jury that there's ways to deal with victimization, and allowing somebody to suffocate in a suitcase while you taunt them is not part of the society that is in accordance with the law.
Yeah. What's interesting about that, my gut tells me of the 6 primary jurors, the 2 men, again, one is grumpy face, the other one is a black male, probably in his early 50s, I would say, in his 50s. My gut instinct, they are convicting her. They are not having much empathy towards her, which is also interesting because this is a female killing a male, and these are 2 males. So the black juror in particular, I mean, he hasn't shown any emotion, but he kind of has there's a sense I'm getting of disgust from him about Sarah Boone. But back to Candy on this one, and thank you to Marplam, who also gifted 5 Surviving the Survivor memberships here. By the way, if you appreciate the content, please hit the like button. Please subscribe. We also have a Patreon link. It goes a long way in helping create great content. Why has the state, Candy, not used Brian Boone, the ex-husband, more to show that Sarah has DV tendencies too? Is there a reason why they haven't used him more?
That's a good question. I was wondering if they were going to bring him back on rebuttal. and ask him some more questions. Maybe they were waiting to, after Sarah was to testify, but you don't want it to be the Ryan, I can't remember his name, Mr. Boone's show.
Brian with a B.
But yeah, I think there's definitely questions that I would have liked to have seen, regarding what was Sarah like in their relationship or her relationship with other people. But I didn't.
By the way, this is interesting too, Candy. Becky Ireland. We don't know why George hated the TV. Could have been because it didn't work. I mean, why is Sarah Boone videotaping it? A lot of people said there's no DV victim out there in the world. I guess a traditional, for lack of a better term, DV victim who would just sit there and record that. They'd be terrified and would be running for their life. So that was an interesting thing to note as well. Let's get into this cross of Julie Harper. She is the forensic psychologist, because I thought the cross was really powerful. Yes, I am Tessie Turner. I put up a little, I got to show people who I am. So I had to put up, the only problem now is I can't open the fridge. I put up a Surviving the Survivor poster. So the fridge is no longer opening, and that's a bit of a problem. I didn't think that far down the road. Ryan, to you. The minute they're done with this testimony, where basically the forensic psychologist says, let me read this. My guest, the state's expert, diagnosed Sarah Boone with narcissistic personality disorder. Great coverage of this trial. I've been trying to catch your lunch break lives. Thank you so much from the Legal Good. Again, really appreciate the super chats here. So back to this cross. So basically the forensic psychologist on direct said, look, she does suffer from battered spouse syndrome. There's different ways to say it, battered partner syndrome, whatever you want to call it. However, it is not diagnosable in the DSM, which is basically the Bible for doctors. So go through all of this. She also admits that Sarah Boone shockingly has some narcissistic tendencies. Get done with that. Will J jumps up, and this was a pretty long cross. I'm going to kind of take us through this. I'll start with Ryan. First thing he says, you had 9 visits with Sarah over 8 days, right? What are the criteria for battered spouse syndrome? And then he's just asking questions. Is control and isolation part of it? Then he says, battered spouse syndrome is not in the DSM, to which she finally answers, right. And then he says, battered spouse syndrome has no statute directing it. And then says it's entirely possible for 2 people to be in a 3.5-year relationship and neither have trauma. He asks, is it possible to be in this 3.5-year relationship and neither have trauma? Is that a good start to the cross, Ryan? What would you have maybe done differently or the same?
It was great. This was an example of how to cross an expert without stepping in the mud. And when we deal with the mental health diagnosis, you're right. The DSM is the standard criteria for diagnosis, so that there is consistency across the board, no matter who the practitioners are. The mental health aspect of diagnosis is so much different than physical diagnosis. I mean, a broken arm is a broken arm, but somebody exhibiting antisocial personality disorder could be defined different. In this instance, by coming right out of the bat with this syndrome does not have standardized criteria, it's not recognized by the American Psychological Association as a mental health diagnosis, leaves an air of not as much legitimacy. So the state can argue, the defense wants you to believe that she's a victim of this battered spouse syndrome. However, this isn't even something that psychologists agree is a diagnosable condition. What this is just somebody wanting to find excuses for their criminal conduct. The other thing that Will did, I think, so well was you tried to be thorough. So on direct, she talked about all the meetings and what she reviewed. Owen showed her pictures. But you do that to try to build credibility. However, Will, I think masterfully, demonstrated you didn't do this, you didn't do this, you didn't do this. And there were two great parts to that. One, from a trial advocacy, just psychological standpoint, I want an expert to say no all the time. You didn't do this. No. And you saw this with Will. You didn't look at this. No, you didn't look at the text messages. You didn't have the phone go. You didn't. And all the while she's saying, no, 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 no. That's great. I mean, that's the way that you question the data set for that expert to reach an opinion. The other parts to it is there's a big difference between when an expert just looks at the information that they're provided, as opposed to using their expertise to say, well, I want to know about this, or can you get me that? The defense tried to make out she's a state expert, she's a defense expert, forensic psychologists have no inclination either way. But there was something that really jumped out to me during the direct of Dr. Harper. And when James Owen was trying to lay out her impartiality, Dr. Harper said that she gets involved in testifies in cases, especially those at risk of succumbing to the death penalty, which to me just demonstrated an extreme bias for defendants. And that may be a subconscious bias or an implicit bias, but still to me, that points out that, well, although you try to be reasonable, and nothing against Dr. Harper, I've never worked with her. I've never worked against her. I didn't know she existed before today. But Will did, I think, a really good job of just inserting a little bit. Will is very well experienced in psychology and mental health cases, especially being a homicide prosecutor. And what he didn't do is he didn't go for the overkill and, getting into the weeds on, is she really a battered spouse? You're never going to win that with an expert. So he did a really, really great job. And most importantly, he made his final points and he sat down.
Yeah, it was a great end. I'm going to continue to go through it. I mean, he ended it on a high note. And I can tell you again, he seemed very happy with himself, as he should, in the hall. I did see people saying, though, it was not an effective cross, which I thought was interesting. Mallory Lozana here. Candy, when we sat in the courtroom as the state rested, it felt like there was an audible gasp that came from many of us. Do you think they presented enough or rested too soon?
I did hear that gasp, and I think my mouth might have fallen open when that happened. I was really surprised. I don't know. I felt like the state could have, delved into a little bit more. I mean, they're preparing this thing for 4 years. I'm sure they have a whole lot more than what was presented. A listener had mentioned, humanizing George. And I understand that there's rules about that, but maybe going into and maybe bringing up more with the medical examiner, what exactly happened to George? What did he experience? What is it like, going down a flight of stairs in a suitcase, or someone hitting you with a bat? I felt just like, we needed to feel what George was feeling.
And again, maybe it comes in a rebuttal. Also, keep in mind that we did find out that the defense says he dragged her down the stairs, which is quite interesting. The bottom line with all this is there has to be an imminent threat. I keep going back to that. I don't see that. That is part of the law. And those 11 minutes of video, plus, obviously the video, the suitcase video, but those 11 minutes between for the defense to say that's when all this happened. Again, I'm just not buying it. he was literally dying at that point. How's he going to get so enraged that she runs upstairs, and why is she going upstairs? And I think at the end of the day, while we're picking apart all the little details and the minutia, I can tell you, having been in court, it's just, I don't know how these jurors can keep track of everything. Every day blends into the other. You forget the details, but you remember the big things, and those are the big things. And I think that's going to have the ultimate impact at the end. I do agree with Goose here. For having only 45 days, can we all admit Owens is doing a decent job? The state has had 4 years. The defense has had, I think they're doing an amazing job. And not only that, he's a nice guy, and the entire team is very friendly. They're excited to be there. I genuinely think that James Owens wanted to help Sarah Boone because of his job as a criminal defense attorney. Is he possibly interested in getting some attention from it? Sure. But I also think, he's got good intentions as well.
Mm-hmm.
Ryan, real quickly,
in the all a big headache as well.
Yeah. Ryan, I was going to ask you a totally different question. Where would we be right now, Ryan? I asked you another one like this, but where would we be right now if Sarah Boone was pro se, if she was leading the charge? What would this look like?
Well, you'd have a concussion from hitting your head so much in frustration, because this thing would just it'd be like a one-legged woman in a marathon. It'd be all over the place. She'd be doing all sorts of improper items. There'd be all of these objections, So for instance, if she is representing herself, every time they have a bench conference, the judge may not be willing to have her go approach the bench. I don't know if I would want to be 2 feet from somebody charged with murder in their murder case if I'm the judge. So that would have slowed things along. It would be excruciating. It would be a root canal without Novocaine for all of us.
How long would it take? I imagine it would take so much longer.
Probably double the amount of time, easily. I
think we would have had the reoccurring statement of, I don't know what I'm doing. You made me do this.
Yeah.
That would have been happening a lot.
Wow. Thankfully, that did not happen. So I guess there's a bit of debt of gratitude to James Owens from Kate Fox. Do you think the state was overconfident? Why didn't they have big posters printed of George's bruises? Ryan, pick that one up. And real quickly, in the closings, are they allowed to play the suitcase video? Are we going to see that? Because I know in the openings they read it, but we're going to actually see it in the closings?
Absolutely. So the difference between the opening and the closing is the opening is a preview of evidence, and we don't publish photos and videos because they're not in evidence yet. In the closings, everything is going to be fair game. So to the listeners or the watchers' question, first of all, this is 21st century, and utilizing the computer, utilizing the overhead projector does a much better job of publishing photos, especially details. As you've seen, Joel, in the courtroom, behind the witness stand, there's probably a 12, 14-foot screen that you can use the overhead camera for. All of the attorneys can utilize laptops to go right into the courtroom AV system to publish. I always would do it electronically and digitally because you can really zoom in a lot closer. From a style standpoint, I think it just makes you look more polished. I'm not convinced that the state was overconfident, and I'm not convinced that the state has just sort of gone along to get along. I think there's two ways to try this case. You either have to try it extremely streamlined, to your point, Joel, of everything that's been going on. The question becomes, why did you video? Why did you wait 11 minutes? Why did you video again? Why did you go to sleep? Why did you call your ex-husband? Those to me are the most damning pieces of evidence, especially those videos. So you either got to try this thing super streamlined and argue to the jury. All the rest of this is just crap, and it's to distract you away from those questions that the defense can't answer. You either got to try it that way, or you got to do the full chicken dinner, and you got to try every single fact and bring in every single piece of possible admissible information. That can be a blessing because it can give a jury all of the background. It can be a curse, though, because for every issue that you put into play, you're now allowing the defense to give their version of it. And if you start having a situation to where there are 20 issues that are brought in and each side has a different interpretation of those issues, I've seen jurors before just throw their hands up and say, the damn thing's so complicated, we're going to find somebody not guilty. So you are dealing with people without a legal background that are willing to serve but have no experience or exposure in the system. So the better default is to keep it as simple as you normally can. So in doing so, the state may not have instilled a tremendous amount of confidence at this point, but that's why the closing arguments are so important, because the trial is nothing more than collecting ingredients, and really closing arguments is cooking the facts together. And the state's going to have a tall task to do with that, especially how streamlined their presentation's been.
Yeah, and I remember, people were really upset with Will in the openings, and now it's a distant memory. No one really even remembers exactly what he said. What I remember is that he read the transcript of the suitcase video, and I thought that was really effective, and that's what I took from it. I made this analogy yesterday, and I think it holds true. And please leave Abby's comment up here. But in broadcast news, it is all about what they call the economy of words, just being succinct and getting to the point. And I think there's a comparison here with prosecuting a case and defending a case. You don't want to talk too much for obvious reasons of opening the door, but also you just want to keep it moving, I think. And I think people are worried about the state's job so far. If I didn't watch Georgia Kappelman and Sarah Dugan just recently up in Tallahassee in the Charlie Adelson trial, I think I'd be a little more nervous right now, but it was a very similar feeling there. And obviously Ryan's been in there and Candy's watched this a million times. They don't look nervous. They look very confident with what they have. And keep in mind, we're still going to see two hours probably of body cam footage tomorrow. So who knows what that holds. From Abbey Crossing here. Yeah, go ahead, Ryan.
And yeah, just one thing real quick on that. We all talked about how the state's opening statements, Will's opening statement went way too long. And there's a danger of that in the closing arguments. In my opinion, if Will starts getting close to or over 45 minutes, you lose the jury. You just lose the jury. And from the psychology of the trial attorney, we pointed this out. He's had this case 4 years and has been through all the ups and the downs. And you get so damn eager to get in there and finally tell the story that you really got to be cognizant that you're tuning people out, especially in today's society of getting my news on X in a 2-minute block as opposed to having to watch 22 minutes of the nightly news. So it's going to be a real challenge tomorrow. Now, if I'm James Owen, I talk ad nauseum and put as much junk out there as I can because you only need one thing to stick.
I think we have a little bit of breaking news I'm going to bring up in a moment because I've seen it a couple of times, and I'm going to ask STS Nation to confirm it. But Abbey Crossing first, friend of the show, friend of ours. The fact, Candy, that she did not know what George said in anger to put her in fear was wild to me, and I want to take a note for that so I can mention that on Banfield tonight. But that's an amazing point. What's your thinking, Candy?
She knows exactly what he said. She remembers. She's just not going to say what that was about. I'm not sure. But,
you just don't forget that, right?
No.
Let me out of the suitcase. I can't breathe. We've already heard what George was saying. And the fact alone that he said it in video 1 And in video 2, said the same thing, although much more incapacitated. There's no reasonable explanation that in that time period he had his last breaths of life in piss and vinegar and anger, and then turned it back off. There's just makes no sense.
It makes absolutely no sense. So I'm going to bring this comment up. STS Nation, see if you can help me confirm this. Not that I don't believe you, Traveling Teresa, but as a reporter, I like to confirm things. But this is not, traditional media. So I'm going to bring this up here. Can Ryan address the state's new motion about conflict of interest in being paid by Sarah Boone signing away her story? Have you all seen it? So a few other people said that I guess James Owens, in exchange for defending her, has given him the rights to her story, which is very interesting. If, and I underscore, if this is true, Ryan, what do you make of this?
That is, so I haven't heard that yet. So you get an unpolished reaction here. If in fact that's true, that's going into my rebuttal case. 100% going into my rebuttal case. And it always astounds me how criminal defendants will find any way possible to monetize or monopolize their moments. It to me is it's sickening to me. I understand, I appreciate, I've seen firsthand, there are people who are arrested who did not commit the crimes in which they are arrested. There are people who are convicted that are later exonerated. It is a fact of life. And I love the First Amendment so much because I have the right to say, within reason, whatever I want to. But, there's a thing to me about capitalizing off of the death of another person. Even if you have gone through this process, even if you are acquitted of a homicide, at the end of the day, somebody's still dead. And just from a human standpoint of wanting to monopolize that for your own financial gain, frankly, makes me ill. Now, from a motivation standpoint and an intent standpoint, this is a common attack against victims, living victims, that somebody is kidnapped, they are sexually assaulted, they are left for dead, and they file civil suits. I represent clients in those situations. And in the criminal trial, oftentimes the victim is attacked for having an underlying motive or reason because there's a pending deal or a pending civil lawsuit. So what's good for the goose is good for the gander. And now I'm interested to read this motion and try to coax some additional information out behind the scenes. But it's a bombshell if in fact it's really true.
I'm not 100% clear. So
her writing her book that I think is kind of leading into her narcissistic traits.
That's interesting. Well, I'm not clear about the motion, though. Would that be the defense? And why would they now be disclosing that, Ryan? Why would it come at the 11th hour?
Well, the defense would have no obligation to disclose it. So it would have to have been something learned about or heard about from the state and the state bringing it forward. Although the defense has to provide reciprocal discovery and disclose any facts that they or any evidence that they are going to use or tend to use, a defendant does not have the obligation to put bad facts out about themselves.
That's interesting. It's really interesting. One of the other things that's been coming up over and over, Candy, in the chat, and I've heard people say this in the courtroom as well, and I'm guilty of looking down, I think, when this was going on because I was taking notes, but when the still shot of her black eye went up, a lot of people are saying it did not look like a real black eye, like it was colored in. Now, by the way, maybe I said that James Owens was somewhat well-intentioned way too early. We're going to find out. So I will retract at least some of that. He's still a seemingly nice guy. But this black eye, Candy Eaton, is there any chance that it could be faked? I mean, how would you even know that? Is that something that should have been investigated? I mean, what do you do?
It looked a little strange to me because I believe she said the heel is what hit her eye. So you'll see up into the arch of the eye, it's black. And then it comes down here as black. And I believe like half of her eyelid is black. But you'll also notice the white of her eye is black, which that would not be happening. So
Ryan, yeah,
we got part of it black up here. I would expect more of her eyelid to be black, but the fact that this whole bottom section was black as well, including the eyeball itself.
Yeah, that's interesting. Ryan, have you ever seen someone put up a fake injury?
Yes, it is so hard to prove, and not to, just to give both sides of this. In one aspect, so this is to my earlier point, this is why I always show digital photos, because when they're printed and blown up on big boards, it's matte finish, crappy paper, and it sometimes doesn't transition well. I also know from working a lot of death investigations that those sorts of injuries in violent crime cases, injuries do present themselves in different ways, and the timing of the photograph is important. The nature of the blow was important. What sort of remedial measures she took right afterwards. Without going in too far of a tangent, while I was on vacation with my kids this summer, I had a bicycle accident and ended up getting an orbital fracture, and had no black eye at all, which was shocking because I threw a raw steak on my face within a couple hours of getting back to where we were. So, physical manifestations of injuries is really difficult. But yes, people fake injuries. People even more likely over substantiate their injuries. I have had instances of people causing their own injuries. So it's, without a lot of medical documentation, it's really hard to prove.
Yeah. So, I mean, it's just so fascinating. My notes just skipped on me here. That's a great point. How come she didn't call police if she was so afraid? And I think that these are the exact questions that the jurors are going to be asking themselves. Just to get back to this cross real quick, when speaking, she had clearly said that she believes that Sarah Boone suffers from BSS, or battered spouse syndrome. And so Will J. Candy on the Cross says, can men have it too? Yes. And Will said, is trauma in the eye of the beholder, which is a great little jab there, to which she responds, it's a complicated response. And then went on, just to try to get as much of this out of the way, he made an analogy about law enforcement responding to really horrible scenes and not being affected. And he was asking her about this. So I just thought this was a really interesting exchange, this notion of trauma being in the eye of the beholder, her saying that she can't really speak to that. But just this notion about this battered spouse syndrome and the trauma, and as Ryan just said, the manifestation of it, because a lot of things with her are just simply not adding up to the diagnosis or the description that this doctor is giving her.
Yeah, it's I believe he gave that analogy a couple of times. He did it yesterday and he did it again today. Kind of like the impression I got was desensitizing. You're seeing something over and over again, so you're desensitized, or this is a normal. Is this interaction between them normal? Homicide detective seeing a dead body. It isn't normal, but it's normal in the
Mhm.
context of a job setting. So you're not surprised, you're not throwing up, you're desensitized to that kind of thing. So I think that's kind of where he was getting on that.
By the way, I am not accusing Sarah Boone of faking an injury. I'm simply posing the question because it's been coming up over and over and over, and she's definitely an odd character. So, Candy is a basically an investigator, once for the public defender and now a private investigator on her own. So I'm just curious if that's the sort of thing that would have been more closely looked at, just to clarify that. Ryan, back to you, back to this cross, and then I promise we're going to wrap in a few minutes because Ryan has to get out of here, and I have to go grab a bite before News Nation. Will J., I thought this was really effective. Speaking to the doctor, says, are you saying a soldier returning from war with PTSD, if he hears a firecracker, that he's justified in going outside and firing his weapon? She said, I'm not saying that. And then he pivots to the use of deadly force in imminent danger, which is the key here. He said she would occasionally flee, and she did not do that. She did not flee that night. Thought that was really effective about the soldier, Ron.
Yeah, it was great. It's a great analogy because when people think of PTSD, that's where our head goes to all the brave soldiers that go over there and put their lives on the line and see just the most horrific things and then have to come back and deal with those. And it's also a brilliant question because what Will's doing there is he is playing on the stereotype that a juror is likely to have. So you have this doctor who talks in these big terms and psychological inventories and analysis this and interviews this and forensic setting that. And then you come back on cross and you make it really more relatable. And lots of people, especially jurors, aren't able to differentiate, or it's difficult for jurors to differentiate levels within something. So if somebody is schizophrenic, they may not be schizophrenic 100% of the time. If they do have PTSD, they may not be triggered 100% of the time. We're seeing more and more defenses based upon autism or autism spectrum disorder, which is wildly varying depending upon the individual, their manifestations, the comorbidities or co-diagnosis. So it was a great point, I think, that he made, and is something that she had to concede on. And also the other part of that question, Joel, that is really spot on is the differentiation between having something and doing something that's justified based on what they have or the condition that they have, because that's going to be the defense's argument. She has BSS, she has PTSD, therefore she was reasonable. And the state can come back and say, well, it's a reasonable person standard, not a Sarah Boone standard, and reasonable people that even deal with these sorts of diagnosis and conditions aren't reacting in the way that she did, especially over a prolonged period of time.
Why didn't she call 911 for Mama Bear in the Great White North? I love Canada. Why didn't she call 911? She did every other time. Again, these are the questions that jurors are going to be asking each other. I'm going to fly through some stuff and then we'll get final thoughts. Will J. then went on to basically ask this doctor many times over if she ever asked if Sarah was telling the truth, or how did she know Sarah was telling the truth? And then he brings up this third bottle of wine. Did she tell you about the bottle of wine? She did not recall ever hearing about this bottle of wine. Did you take into account alcohol consumption? He asked, did she simply just not remember things? And the doctor responded, it is normal for people to not remember everything. And then Will J. stopped and said, I'm not talking about everything. I'm talking about the 20 minutes where this death occurred, going back to the whole issue of what was said that triggered her. Suddenly she couldn't remember that. Will J. also reminds everyone by asking the doctor this, what did she say to you? She told me it was a good day. She said it wasn't zipped all the way. And Will points out that at the very beginning, it was of this suitcase incident, it was still funny to them, he asks. And she says, correct, it was funny. Then he got mad, and she says, correct. And that made Sarah mad, correct. She said something made her mad. And he goes, you didn't ask her to elaborate? No. Why? Because a traumatized person opens conversations, and requires open conversations, not interrogations. And he says, well, you had 9 visits. Did you ever ask what made her so mad? And boom, a couple more things. And is lying to police helpful? Or do you agree that she's not been truthful? On and on it goes. And he says, in all 9 visits, you never asked about these things. He reiterates that. And finally asks Ryan, you never had the opportunity to interview Jorge Torres, obviously, correct? Which I was like, at first I thought he was making a mistake. Obviously, it was an exclamation mark. He says, no further questions. Was it a thing of beauty in your eyes, Ryan?
It really was. And so my wife's a digital forensics expert. She'll say, all the time, garbage in, garbage out. And the problem with the psychologist's testimony is it's based off of Sarah. And if she's given her garbage in, then the opinion's going to be garbage on the way out. And what Will was able to do there was to outline where what Sarah told the psychologist is different than what Sarah told the police, and even different than what Sarah told us yesterday in her testimony. And that goes a tremendous way to lessen the blow of the opinion. And it presents a great opportunity for the state in closings to say, look, if Sarah was an honest person, then the testimony of Dr. Harper would have more relevance here. But Sarah is the only person that could talk about the dynamics. And if Sarah's a liar, not calling Dr. Harper a liar, it colors the credibility of the opinion. And the last point about George, it's an objectionable question. I love it though, because he's right that this is an opinion based upon a dynamic of 2 individuals. And Sarah Boone was the one who decided that Jorge Torres, or that George could never be interviewed in this case.
Yeah. Well, you just heard from best guest Ryan Vestio, a former homicide prosecutor in the very county where this is all taking place, now a victim's attorney. Thank you, Ryan. And Candy Eaton, who is a former public defender investigator for over 30 years, now with her own PI firm. By the way, this is the motion that was filed late today about James Owens benefiting. The COE will put that into Patreon. You can support us there and read the document. Those are the types of things that the COE is adding to the Patreon page. Candy, your final thoughts as we say goodbye tonight.
This all is hinging on imminent danger, and I just don't see it.
Hey, you can't get more succinct than that. Imminent danger. We don't have that. We do have the suitcase video. I agree with Candy. I think this is going to result in a guilty verdict. Could it be manslaughter? Maybe. We don't know. We're back tomorrow all day, lunch live, then the evening show. And don't forget, we're adding in. We are adding a Adelson show. I entered 5 different book awards. I have no idea what they even are. And I was notified last night. And honestly, I haven't even read the email closely. I did not win, but I was a finalist. So there you go. I got a little seal that I'm allowed to put on my book now. And I will fill you all in once I find out what it actually is. I literally have not had time. But love you, America. Love you, Orlando. Candy, thank you for being with us for the very first time. And we will see you all tomorrow on the flip side.